A shopkeeper keeps his customers udhaar. A shopkeeper keeps his customers udhaar entries in a paper register. His neighbor keeps the same entries in a phone app. Same names, same amounts, same purpose. Under the DPDP Act, one of them is processing regulated personal data, and one of them, for that register at least, is outside the Act entirely. If that distinction surprises you, today's episode is going to be full of surprises. Because before any talk of consent or penalties, there's a gate every situation must pass through. Is this personal data in digital form within the Act's scope? Get that answer wrong in either direction, and you'll either ignore real obligations or drown yourself in imaginary ones. You're listening to DPDP Daily. I'm Harmeet Singh Kapoor. I've spent my career running large programs and portfolios, the discipline of making complex things actually happen, and for the past few years, I've brought that discipline to India's data protection law. I wrote the DPDP Act Compliance Handbook, From Law to Ground Reality, and this show is that book, opened up one episode at a time. If you're new here, the 30-second background: in 2023, India passed its first comprehensive data protection law, the Digital Personal Data Protection Act. In November 2025, the government notified the rules that make it operational on a phased clock that runs to full enforcement in May 2027. Together, they decide what every company, hospital, school, app, and shopkeeper in this country may do with your personal data, and what you can demand when they get it wrong. 15 minutes a day, no jargon, real answers. Let's get into it. Start with the definition because it's short enough to hold in your head. Personal data means any data about an individual who is identifiable by or in relation to such data. Three load-bearing phrases in there. Any data about an individual, identifiable. Let's take them in turn, then add the boundary that limits everything. The Act applies to personal data in digital form or collected offline and digitized later. Any data is deliberately vast. Name, phone number, address, obviously, but also location trails, purchase history, voice recordings, photographs, device identifiers, opinions about a person, and employees' appraisal notes. India rejected the closed list approach of the old SPDI rules, where only enumerated categories were protected, and remember from our legislative journey episode, the Act also declined to create a heightened sensitive data tier. One definition, one level of statutory protection. Your health record and your food preferences sit in the same legal category, though practically the sensitivity of data still matters when judging what security is reasonable and what harm a breach threatens. The Act flattened the categories, not the risk. About an individual, a natural, living person. Data about a company as such, its turnover, its GST number, is not personal data, but the moment data points at a human, it qualifies. And this is where businesses miscalculate constantly. A business email like priya.sharma@company.com is data about an identifiable individual. Your B2B contact database is full of personal data. Your vendor's delivery boy's phone number in your dispatch sheet, personal data. We're a B2B company. This law isn't for us, is one of the more expensive sentences in Indian compliance right now. Identifiable, and here's the sophistication. The individual need not be named in the data. It's enough that they're identifiable by or in relation to it. A mobile number identifies without naming. A vehicle registration, a device ID, a customer code that your other systems can resolve to a person, all identifying in relation to other data you hold. The practical test I give teams. Could someone using this data plus other data reasonably available to us single out the individual? If yes, treat it as personal data, which is also why lazy anonymization fails. Replacing names with customer IDs while keeping the mapping table doesn't take data outside the definition. It's pseudonymization, a fine security measure, still fully personal data. Genuine anonymization, where re-identification is no longer reasonably possible by anyone, takes data outside the Act's concern, but that bar is higher than most teams assume, especially with rich data sets where combinations of ordinary fields can single a person out. Now the boundary that shapes daily life. Digital form. The Act covers personal data processed digitally and personal data collected offline that is subsequently digitized, which resolves our opening puzzle. The pure paper register, never digitized, sits outside this Act. Photograph it, type it into Excel, message it on WhatsApp, it enters the Act's world at that moment. Three honest observations about this line. First, it's a real and intentional limit. India regulated the digital economy, not every notebook in the country. Second, it's narrower than it looks because almost everything eventually touches digital. The clinic's paper form gets scanned, the visitor register gets photographed for the audit, the wedding guest list becomes a spreadsheet. If your process ever digitizes, build compliance for the digital destination rather than celebrating the paper origin. Third, don't hear this as advice to retreat to paper. Paper leaks too, other laws still apply, and a business running on paper to dodge a data law has chosen the wrong century. Two more exclusions complete the map. Personal or domestic processing, your own contacts, your family WhatsApp group, your personal diary app, outside the Act. The neighborhood auntie maintaining her mental database of everyone's affairs remains mercifully unregulated, and data that the data principal has herself made publicly available or that's made public under a legal obligation, carved out. The influencer's public posts, the company director's details on the public registry, but mind the carve-out's edges, data that leaked into public view or was made public by someone other than the individual doesn't enjoy the exemption. It was findable online is not a magic phrase. Now the edge cases that fill my inbox because the definition earns its keep at the borders. CCTV first. The footage from the camera at your shop entrance is digital data about identifiable individuals. Personal data, full stop. Recognizable faces, vehicle plates, gait, identifiable in relation to is a low bar for video. That doesn't make CCTV unlawful. Security is a genuine purpose, but it makes the footage part of your data estate. Who can view it, how long you keep it, whether the feed goes to some vendor's cloud, all become real questions. The camera aimed inside your own home for family safety rides, the personal use exemption, point a lens at a workplace or a shop floor and you're processing. Biometric attendance machines next, the fingerprint or face scanner at offices and factories everywhere. Biometric templates of identified employees, personal data of a particularly consequential kind, since you can change a leaked password but not a leaked fingerprint. The Act may not create a sensitive data tier, but remember the principle from earlier. Flatten categories, not flatten risk. Reasonable security for biometric templates means more than it means for a mailing list, and an organization that treats the two identically will find the board unimpressed after a breach. And the boundary between personal use and business use, which WhatsApp has blurred for an entire economy. Your family group, outside the Act. The moment the same phone runs your business, the customer's broadcast list, the group where staff share order details, that processing is commercial and the personal use exemption stops covering it. The device doesn't determine the law, the purpose does. For lakhs of micro businesses, the honest headline is that their entire data estate lives inside one phone, which is why my advice to them is always the same and always cheap. Separate the business data, lock the device, and treat the contact list like the asset and liability it now is. Let me close with the exercise that makes this episode operational. Take 5 data items from your own organization, say the customer WhatsApp list, the CCTV footage at your entrance, the employee attendance biometrics, the analytics dashboard, the old paper visitor book, run each through the gate about an individual, identifiable, alone, or with what else we hold, digital or headed to digital. Within a carve out, that 5-minute drill, honestly done, produces your first real scope map. And everything this podcast covers from here operates inside that map. Tomorrow, the mirror image of today, what the Act does not cover, the exemptions from personal use to the government's wide lane, and why knowing the edges of the law matters as much as knowing its center. That's today's episode of DPDP Daily. If it made this law a little clearer, do one thing for me. Send it to one person who needs it. That's how this show grows. Everything I covered today, with the templates, checklists, and audit frameworks behind it, is in my book, the DPDP Act Compliance Handbook From Law to Ground Reality. And I post one practical DPDP insight every morning. Find me on LinkedIn and on X and Facebook as well under Harmeet S. Kapoor. One important note, this is education, not legal advice. For decisions about your organization or your rights, take proper professional advice on your specific facts. New episode every day. I'll see you tomorrow.